Courts have found that the states and towns do have a substantial government interest in regulating signs to prevent things like blight and visual clutter and danger to drivers and so forth. The important thing with that is that we're still here talking about regulating signs generally, not necessarily singling out political signs for any other kind of treatment. So this is the test that would apply to those, to the analysis of sign regulations generally. When you go beyond the general regulations and start singling out political signs for a different treatment, you cross into a much more difficult regulatory area because you're regulating the content of the speech, which is something that courts are very reluctant to sustain. If your political signs, for example, have smaller size restrictions, smaller number restrictions, if they can be up only a shorter period of time than the St. Mary's Church Bazaar yard sale car wash signs, you would have to demonstrate that those restrictions serve what is called a compelling governmental interest, and frankly that test is rarely if ever satisfied. So to kind of back it up a little bit, if you're going to be regulating political signs any differently than you regulate signs generally, including commercial signs, identification signs, and so forth, you have to have a damn good reason. And courts have been very reluctant to find good reasons for treating political speech any more restrictively than commercial speech. I guess the point of this discussion is that if you're going to be regulating political signs, it is per se a regulation based on content, and if you treat them any differently than you do other temporary signs or other permanent signs, you're skating on thin ice. I guess is not the legal term, but
it paints a very adequate
picture. Yeah. I think by now everybody in North America has seen the November 2010 letter, and at the end of that, I had kind of cut and pasted a whole bunch of different political sign regulations from towns all over the state, and as you can see in there, the regulations ranged from the sublime to the ridiculous. Some of them had no restriction whatsoever other than that they didn't block sight lines on the road and that they weren't within the right-of-way. Others limited them to 2 square feet, others required permits, that kind of thing. And, I think the reason the regulations are all over the place is that most of the towns probably have the good sense not to try to enforce ones that they have been advised are unenforceable.
Is there a focus that should be more on the federal level or the state level if we were trying to determine constitutionality?
I think fundamentally both the federal and the state constitutions say you can regulate signs. The difference is that as it stands now, there isn't a good, sufficient body of Connecticut law telling you how, if at all, your ability to regulate political signs differs from the rights that are available under the federal constitution. Federal constitution jurisprudence on these kinds of issues is really relatively well developed. I mean, it doesn't give you, it doesn't necessarily give you the silver bullet answer to every scenario that you're going to be confronting. It does give you kind of a roadmap, as far as where the respective third rail is on the side of the road. I don't think for purposes of sign regulation, I don't think there's enough case law in Connecticut to give you meaningful guidance on whether the protections are greater. As far as the black and white regulation of signs on private property, I don't know that you gain anything by focusing on the Connecticut Constitution.
Aren't political signs held above all other signs? Other forms of speech? And aren't there, there can be no commercial signs larger than the political signs, because they're held above.
Yeah, I think that was kind of what what I started with, and I don't know whether you got here after that, but it was basically the premise is that, yes, they are entitled to substantial protection, and that I think to the extent that you would allow commercial signs either larger for a longer period of time or in greater abundance than you would political signs, I think you would be significantly at risk of having it found to be unconstitutional, because that is...
So we can start with that premise.
Yeah.
Is you cannot yell fire in a crowded theater. That's not free speech. I mean, if I say to you, Sean, I disagree with you, I can do that. If I get 2 inches from your nose and I scream at you, that's not the same thing. So that there isn't, sometimes it's not what you do, the way that you do it, but the reason why I think that Attorney Roberts came down here was to guide us through this process of correcting what we acknowledge to be a weakness in our job. I don't think, and I'd like to go around the room and get some more opinions while Attorney Roberts is here, that the intent was to throw out all attempt to regulate as much as to correct what might have been potentially unconstitutional